Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. Today, I am going to discuss state liability for protection of human rights. This is my 29th lecture, and in this lecture, I would like to highlight what is the state role, what is the role of responsibility of state in order to protect the life of its subject citizen. So, in this lecture, I would like to highlight sovereign and non-sovereign function, and I would like to highlight the role of Supreme Court, how Supreme Court has been effective in protection of human rights of the citizen of this country, and if whether it is the duty of a state to protect the human rights of a citizen. So, with the help of judicial pronouncement, I will try to make a thorough analysis whether state has been effective in protection of human rights. So, with slight deviation, you will find that in many cases Supreme Court has played very effective role in protection of human rights of the citizen of this country. So, you can see on your screen that I have chosen this topic just to emphasize the role of state for the protection of human right. So, you all may be aware that right to life is a human right. Every person has a right to live with human dignity, where it is provided. Article 21 of the Indian Constitution and Article 3 of the UDHR talks about that every person has a right to live in human dignity. Right against inhuman treatment, illegal arrest is given under Article 5. Why state is liable for violation of human rights? Why state can be held responsible for violation of human rights? I will discuss in detail. Ultimately, why? The reason is ultimately state is constitutionally obliged to protect life and limb of its citizen. Ultimately, state has to protect life and limb of its citizen. So, for that reason, it is constitutional obligation of state to protect life and limb of its citizen. So, with this background, I would like to highlight sovereign function and human rights. How sovereign function which is exercised by the government, and in this lecture I would like to highlight whether in the name of sovereign function government is free to do anything, whether in the name of sovereign function government can breach the law, whether in the name of sovereign function government can violate the rights of people of this country. So, we will try to understand with the help of judicial pronouncement. You see, the first case where Supreme Court held that government would not be responsible in case of sovereign function, where government is performing sovereign function and any wrong is committed by its employees, servant, government would not be responsible for that. So, how government is responsible for the wrong committed by its representative, its employees? This liability arises from that Latin maxim which says that Q facit per alium facit per se. Q facit per alium facit per se means one who acts on behalf of another is supposed to act on his own behalf. For example, if I have been delegated some power by my father, so I am acting that act on behalf of my father, because my father has delegated some power to me that you should take this item from the market. If that power has been delegated by my father upon me, so it is my responsibility to purchase good item from the market. if I am not purchasing, if I am unable to purchase that good item from the market, then it means I have not performed my duty in accordance with the power delegated by my father. Meaning thereby, similarly, the same thing is applicable in law also, where state has employed its employee, employees are supposed to perform state duty in accordance with the law. If police officers have been appointed by the government, by the state government, all the police officers are supposed to perform their duty in accordance with the law. In accordance with the law. So, if any police officer who has violated human rights, who has violated fundamental rights of a common man, then not only the police officer would be held liable for that, but state government can also be held responsible for the violation of rights of fundamental rights of common man, because that police officer was working as agent, as a representative of the state. So, for that reason state is also responsible for the wrong committed by the police officer. So, with this idea, state liability is fixed in law. State is responsible for the wrong committed by its officers, by its employees, and human rights, if human rights are violated by the government representative, not only the representative would be held responsible for the breach of fundamental rights or human rights, but the representative, but that personality, that entity would also be held responsible for whom benefit those employees, those officers are working. So, obviously state would be responsible for any wrong, for any crime committed by the officers. Many times you might have seen that police atrocities, police violence, custodial violence, in case of police atrocities, in case of custodial violence, state government has to pay compensation for the violation of fundamental rights of the citizen. Why? If police officer has violated fundamental rights, if SHO has violated fundamental rights, has committed custodial violence, then why state government should provide compensation to the victim? Because that SHO is working on behalf of the government. SHO is the representative of the government. In that representative capacity, he was appointed to maintain law and order, and maintaining law and order, if he has breached the law, if he has violated fundamental rights of any citizen, then SHO as well as state government under whose supervision that SHO is working, both would be held responsible for that. So, with this I would like to explain one important case which all the students might be aware. That case is, the name of that case is Kasturi Lal versus State of UP, AIR 1965 Supreme Court. Kasturi Lal case is a very leading case on this point, where Supreme Court for the first time in 1965 made clear-cut difference between sovereign function and non-sovereign function. Sovereign function here means function which is performed by government in order to maintain law and order, in order to maintain peace in the society. So, if government or government representative is working for maintaining law and order, peace in the society, and during that period if they commit any wrong, so whether they should be responsible for that or not, it has been matter of debate. The first question which came before the Supreme Court regarding sovereign and non-sovereign function is Kasturi Lal versus State of UP, AIR 1965 Supreme Court. The facts of this case will open your mind that what happened in this case, and Supreme Court, how Supreme Court decided that on the basis of sovereign function, government representative employees could not be held responsible for that. You see, what happened in Kasturi Lal case, Kasturi Lal was a businessman and he was having a gold. He was arrested by the police. He could not give justification for having gold. He was a businessman. You see the period, the case was decided by Supreme Court 1965. It was the year of 1965. And when police, two constables, when they arrested him and his gold was confiscated, forfeited, and Kasturi Lal was told that unless you give justification for these golds, your gold will not revert back to you. So, firstly you provide justification for having these golds, whether this is stolen golds or these golds you have purchased from any shopkeeper. You provide receipt, meaning to say that you provide a receipt for that, from where you have taken this gold. Until that, this gold is deposited in this police station. So, he went in court and he stated the entire story before the court, that he was a Kasturi Lal was a businessman and he was going for a business. He was arrested by the police. They have confiscated their gold. They are not returning back to the gold. Now, see, the irony of law is when he went in appeal before the Supreme Court and he stated that his gold was confiscated by the concerned police station. The plea which was taken by government counsel was very interesting in this case. Government advocate took a plea before the court. The constable who had searched this Kasturi Lal, they were performing their duty. They were supposed to perform law and order. But one constable who had taken all the gold coin had absconded, left this country and went to Pakistan. So, government advocate took a plea before the Supreme Court that that constable had run away with all the golds, and it appears that he went to Pakistan and we are unable to find him. You see, this is the first case. Supreme Court said that if constable could not be found, because the constable who had confiscated gold had run away from this country, left this country, so government is unable to trace him. And constable were working sovereign function at the time when Kasturi Lal was searched. So, that is why government would not be responsible for a single piece of gold. So, Supreme Court for the first time held that constable, they were performing sovereign function. So, government would not be held responsible for the loss of gold of this businessman Kasturi Lal. State is not liable. This petitioner Kasturi Lal wanted to take back his gold from the police. He pleaded before the court that he was having this receipt. This is the receipt, and at the time of arrest, he was not having this receipt. Right now, he has produced the receipt from where, and he was a businessman. But when government took a plea that constable had left this country and we are unable to trace him, so that is why government should not be held responsible. Supreme Court said it was a sovereign function, and in sovereign function government is not responsible. So, you see this case was decided by Supreme Court in 1965, and you can see on the screen I have Kasturi Lal versus State of UP. Q facit per alium facit per se. This is the Latin maxim which I have just referred. English meaning of this Latin maxim is one who acts on behalf of another, that is his own act, vicarious liability, master servant liability, principal agent liability. So, how it, if agent, suppose if LIC agent is working, if LIC agent has collected premium from the consumers, that agent is working on behalf of LIC, Life Insurance Corp, LIC. After collecting premium, suppose he has absconded. So, who will be responsible for that? For the premium? Obviously, LIC will have to compensate. LIC will have to revert back all the premium, the amount of premiums to the respective consumers from whom its agent, LIC agent has taken money. Because agent was working on behalf of LIC and consumers people, they have deposited their money to that agent, believing that agent will deposit that premium in the office of the LIC, and that agent, LIC agent has absconded. So, who will be responsible? Obviously, LIC would be responsible. LIC will have to revert back all the amounts to the respective consumers. So, this is known as vicarious liability. So, where agent has committed any civil wrong, the principal of that agent would be responsible. Similarly, where a servant has committed any wrong, civil wrong, so his master, under whose supervision that master would be responsible. Suppose if my servant has committed any wrong, I would be responsible for the wrong committed by my servant, but I am not responsible for any crime which is committed by my servant, because you need to remember that there is a clear cut difference between tort and crime. That tort is a civil wrong, civil liability, and crime is a public wrong. So, vicarious liability, the concept of vicarious liability is not applicable in crime, in criminal law. So, neither agent nor servant, where servant, if my servant has committed murder, I would not be responsible for that murder which my servant has committed. Similarly, if LIC agent has committed murder, the manager of LIC would not be liable for that murder. This liability arises only in civil case. You need to remember that this liability arises only in civil cases, not in criminal cases. So, this is the first case where Supreme Court, on the basis of sovereign function, exempted the state from the civil liability and held that state would not be responsible for any act which is committed by its representative during course of employment for sovereign function. State will not be liable. But later on, Supreme Court said no, sovereign function will not exempt any representative of the state from liability. Here Supreme Court has diluted the concept of sovereign function, and in this case I would like to discuss how Supreme Court has relaxed its view. Vidyauti case, you can see on your screen, Vidyauti case analysis. The name of case is State of Rajasthan versus Vidyauti, EIR 1962 Supreme Court. Before I start this case, I just want to explain you the applicability of Article 300, where it is specifically written that state can sue and can be sued. State can sue and can be sued. It is Article 300 of the Indian Constitution says that Government of India can sue and can be sued. According to Article 300, Government of India, Union of India is a legal person which can sue and can be sued. State government is a legal person which can sue and can be sued. So, from where this liability arises? It is Article 300. Union, state government can sue and can be sued. Action can be taken against the state government. Action can be taken, civil action can be taken, civil suit can be initiated against union government and state government. If state representative has committed any civil wrong, state government would be responsible. If any officer of the Government of India has committed any wrong, then Union of India would be a party, Government of India would be a party, and individual victim has right to file a suit, civil suit against the Government of India, against the state government. I just want to correlate Article 300 of the Constitution with Section 80 of the CPC. You just you look at your screen, Section 80 CPC in civil matters, Section 79 and 80. Section 79 talks about legal personality of the state in civil matters. 79 says that state can sue and can be sued in civil cases, and Article 300. So I have just written this so that you can have complete understanding about. You see what happened in state of Rajasthan versus Vidyavati case. In this case, a driver of state government who was driving a car from workshop to the district magistrate DM residence. What happened in this case, state of Rajasthan versus Vidyavati? A government driver working under the supervision of state of Rajasthan, when he was driving a car to take district magistrate for the office, when he was driving his car from workshop and when he was going to DM residence, during that period, due to that car, a person died. Driver could not control over the jeep, over the car, due to which deceased died. The deceased wife Vidyavati filed a case against the government, stating that at the time of death of her husband, government driver was driving car, was going to take DM district magistrate from his house. So that wrong was committed, that accident was committed by a driver, by a representative of the government who was acting on behalf of state government. So that is why deceased wife Vidyavati should be compensated, should be provided compensation. Government advocate, the plea which was taken before Supreme Court by government advocate was sovereign function. Government advocate said that driver was going to take district magistrate from the workshop to that place. That was a function of that was a government function, and during performance of government function, if anything is happened, government is not liable for that. So, that act should be considered as sovereign function. On the basis of sovereign function, state is not responsible to pay compensation to Vidyavati, to the wife of deceased. But Supreme Court did not accept the plea of the government, and Supreme Court held that in this case sovereign function cannot be accepted as a defense, and state government is responsible to provide compensation to the wife of deceased, and Vidyavati was allowed to get compensation from the state government. This is leading case where Supreme Court for the first time rejected the plea of the government and awarded compensation to the victim, to the Vidyavati, and state government, Rajasthan government was directed to provide compensation to the Vidyavati. So, what I am trying to justify, how you see state is liable for protection of human rights, because see, Vidyavati had lost her husband and she had right to live with human dignity. That is her human right. So, state is responsible for the protection of human right. That is why Supreme Court did not accept the plea of government, and Supreme Court said state government is responsible to provide compensation to the deceased wife Vidyavati. This is another important case. So, you can see that how Kasturilal case and Vidyavati case is different from that. Now, come to this another important case, state liability for police atrocity. The question is whether state is liable for police atrocity, whether state is liable for custodial violence. I have chosen two important case laws. The first is PUDR versus State of Bihar, AIR 1987. Second is Khatri versus State of Bihar, AIR 1980, Supreme Court. This PUDR versus State of Bihar case, this case is known as where police fired on farmers who were peacefully assembled in Patna. Khatri Bhagalpur blinded prisoner case. So, this case, you see, I have chosen these two important case laws just to explain the liability of state. You see, Supreme Court in this PUDR case, PUDR versus State of Bihar, AIR 1987, Supreme Court. I just want to throw some light on this case. The facts of this case are what happened. You see, about 700 to 800 farmers, including children and women, they were demanding their democratic demand from the government. They were assembled at Patna. They were peacefully demanding their demand, but police appeared at the scene of crime without any prior information. They fired on the mob. As a result of that, many farmers, including children and women, died. Since farmers were poor, they were not in position to bring their matter in the court of law. So, it was decided by that NGO PUDR, People Union for Democratic Right. That NGO took responsibility to fight the case of those farmers who had lost their lives in that incident. The matter was brought into the notice of Supreme Court, and Supreme Court, without taking any second view in this case, held that state government was responsible for the death of poor farmers. You see, the interesting thing is that even in this case, government took a plea before the Supreme Court that police officers, they were performing their duty and they were deployed at that place just to maintain law and order. Supreme Court asked the government whether there was any possibility of unrest violence, government, state government could not establish a single fact before the Supreme Court that there was any possibility of violence due to that mob. So, Supreme Court held that all the police officers who were involved in that incident must be punished for the death of those poor farmers, as well as state government was directed to provide compensation to the deceased, to the family of deceased farmers. So, you see how state would be held responsible for the violation of human rights, where death is caused by negligent act of the police, state would be responsible. The second important case on this point is Khatri versus State of Bihar, EIR 1980 Supreme Court. What happened in Khatri case? That case is also popularly known as Bhagalpur blinded prisoner case. Bhagalpur blinded prisoner case, this case is popularly known as Bhagalpur prisoner case because that incident took place in Bhagalpur district, wherein about 34 prisoners, under trial prisoners, against whom police officers, they had poured acid chemical in their eyes, and due to which about 34 prisoners, under trial prisoners, they lost their eyesight. Since they were poor, they were not in position to bring their case in the court of law. So, Kapila Hingorani, she is known as mother of PIL in India. So, Kapila Hingorani was a leading lawyer at the Supreme Court at that time. So, she took responsibility to fight their cases, to fight the cases of poor under trial prisoners, and she filed a petition in the Supreme Court by highlighting the plight of under trial prisoners, that police brutality. Supreme Court in this case did not accept any plea of the government of Bihar. Supreme Court said that the act committed by the police against 34 under trial prisoners are a heinous crime, custodial violence, naked violation of human rights. Supreme Court made very objectionable remark in this case, and Supreme Court said that it appears that in the state of Bihar there is no law, and police officers, they had taken law in their own hands, and this is the naked violation of human rights. All the victims, they were provided medical aid free of cost. They were transferred from Patna Medical College to Delhi AIMS, and their treatment was allowed free of cost by the Supreme Court. Supreme Court issued direction to the government concerned and Delhi Hospital to take to bear all medical expenses which might occur in that case. So, you see, this is how Supreme Court considered this case as a heinous crime committed by state representatives, and state would be responsible for the wrong committed by its representative. So, in that capacity, Supreme Court held all the police officers responsible, and all the police officers were punished for committing grievous hurt. So, grievous hurt, they were prosecuted and convicted for committing grievous hurt. This is all about your state liability for police atrocity. These are two important case laws. You can understand this with the help of these two important case laws. Now come to another important case, state liability in custodial violence. I have chosen this two important. Nilavati, how state is liable for the wrong committed by its representative. Nilavati Behra vs. State of Odisha, AIR 1993 is a case. Shaheli, a women resource center versus Commissioner of Police. Nilavati Behra case, what happened? This case is custodial death. I have highlighted in brief custodial death of 16-year-old boy. Compensation was awarded to the mother of the deceased. So, you see, I have just highlighted that how custodial violence committed by police was taken care of by the Supreme Court. Here in this case, Supreme Court awarded compensation for custodial death, where the representative of the state, they are indulged in violating human rights. As a result of that, if custodial death is committed, custodial death occurs, then all the police officers would be held liable for the death of the deceased. Not only police officer would be held responsible for that, but state government on behalf of state government for which they are working, state government would be responsible for the wrong committed by its representative. So, you see how state is liable for the wrong committed by its representative. Supreme Court, through its judicial pronouncement, has established that whosoever will violate human rights of the citizen would be punished for violation of human right, and state government would be compelled to provide compensation to the victim. Compensation as a part of rehabilitative scheme, compensation as a part of restorative justice, that compensation must be provided to the victim. Supreme Court has evolved this compensatory jurisprudence in order to provide financial benefit, economic benefit to the victims. In Nilavati Behra case, in my previous lecture, I have already highlighted the facts of these cases when I was talking about constitutional law. So, here it would be pertinent to mention in brief that in Nilavati Behra case, when her 16-year-old boy was found dead on a railway track nearby a police station, she lodged FIR at the police station. Police officer, they did not pay any heed on that. She wrote application, the name of Suman Nilavati Behra. So, she wrote a letter to a judge of the Supreme Court by stating entire facts. So, matter was taken into notice, and it was found that on the basis of postmortem report and other relevant factors, Supreme Court found all the police officers guilty in this custodial death, and Supreme Court held that deceased mother should be provided 1,50,000 rupees as a compensation. The important thing is that where police officers are found guilty in violation of human right, they shall be compelled to provide compensation to the victim of crime. Though it is the state has to provide compensation, immediate relief to the deceased. At the same time, state government can recover that amount of compensation which state has provided to the victim of crime. So, state government will collect amount of compensation from the culprit, from its own representative who has committed wrong, who has committed custodial violence. So, state government may collect whole amount of compensation from from the police officers. Now, let us see state liability and other cases, how state is responsible for the violation of human rights. Now, come to this state liability for illegal arrest, where some person is arrested illegally. The question is whether state is liable for illegal arrest. I have chosen two important case laws. One is Bhim Singh versus State of Jammu and Kashmir. Second is Rudal Shah versus State of Bihar. You can see these two cases on your screen. Bhim Singh versus State of Jammu and Kashmir. Rudal Shah versus State of Bihar. AIR 1982 Supreme Court. What happened in Bhim Singh case? I have chosen you just Bhim Singh versus State of Jammu and Kashmir. Ubi just ibi remedium. That is Latin maxim. Ubi just ibi remedium. Where there is a right, there must be remedy. Petitioner was arrested by police when he was going to participate in assembly session. I have mentioned the facts of this case in brief. In Rudal Shah case, petitioner was to be released in 1968 but remained in jail till 1988. State was held liable for. Why I have chosen these cases? Because it would be better for you to remember all these cases, and these cases are very important in other papers also. For example, you might have seen that whatever cases I have referred in this lecture, you can find all these cases in your constitutional law, in IPC, in Evidence Act. So, if you remember all these cases, it would be better for you that remembering all these cases would be very helpful, not only in this paper, but in constitutional also, in CRPC also, in Indian Penal Code also. So, for that purpose, I have chosen those important case laws which are very common in many law papers. In tort also, if you have any idea about tort, if you just can see that in state liability you may find all these cases. In vicarious liability, Q facit per elim facit per se, you can find all these cases. To some extent, you can also find all these cases in Ubi Jus Sibi Remedium chapter, Injuria Sine Damnum, Damnum Sine Injuria chapter. So, here I would like to discuss two important case laws, Bhim Singh versus State of Jammu and Kashmir, Rudal Shah versus State of Bihar. What happened in Bhim Singh versus State of Jammu and Kashmir? Bhim Singh was a member of Legislative Assembly, MLA. When he was going to participate in assembly, he was arrested by the police, due to which he could not participate in assembly session. Although his arrest could not affect the legality of proceeding of the Legislative Assembly, since he was a member of Legislative Assembly, since he was MLA, he was arrested by the police, he could not participate in assembly session, he challenged the constitutionality of his detention, arrest before the Supreme Court. This is a leading case in that head, in that chapter, Injuria Sine Damnum, infringement of legal right without damage. Though he could not suffer any monetary loss, but his right, his legal right was infringed, violated, infringement of legal right without damage. This is appropriate case, this is a very leading case in that head, in that chapter, Injuria Sine Damnum. This is a leading case in Ubi Jus Ibi Remedium, where there is right, there must be remedy. Article 32 of the Indian Constitution, Ubi is based on Ubi Jus Ibi Remedium, where there is a right, there must be remedy. All the fundamental rights would be meaningless if Article 32 would not have been incorporated in the Constitution, because Article 32 clause 1 says that any person may come to the Supreme Court for what? For the enforcement of his fundamental rights or her fundamental rights. So, right to move before the Supreme Court itself a fundamental right under Article 32. Where fundamental right is violated by state or by individual, that victim whose fundamental right has been violated has right to come directly to the Supreme Court. So, if Article 32 would not have been provided in the Constitution, it would be, then all the fundamental rights would have been meaningless, insignificant. When it was asked to the Dr. B.R. Ambedkar, Chairman Drafting Committee, that which provision of the Indian Constitution is the best to your knowledge, so he said that if he will be asked to say that which provision of the Indian Constitution is the best provision, he said that to my knowledge Article 32 is the soul of the Constitution. If Article 32 is separated from the Constitution of India would be dead, would be insignificant. So, highlighting the significance of Article 32, Dr. B.R. Ambedkar said that Article 32 is the most important provision of the Indian Constitution. So, what I wanted to justify, that is Article 32 is based on ubi jus ibi remedium, where there is right there must be remedy. This Bhim Singh versus State of Jammu and Kashmir case is a best case on this Latin maxim. So, Supreme Court held that arrest was illegal, unconstitutional. The police officers who were arrested him, they had violated his fundamental right. So, state government of Jammu and Kashmir was directed to release him, and state government was also directed to provide compensation to the petitioner, and state government had to pay compensation to the petitioner. Now, the second important case on this point, which you all are aware about that case, that is Ruddal Shah versus State of Bihar, AIR 1982 Supreme Court. I have chosen all these cases which are very common in tort, in the Constitution, in the human rights, in the CRPC, or this, so that is why I have chosen those important case laws, so that you can remember. What happened in Ruddal Shah case, the thing is very clear, that Ruddal Shah was arrested, was kept in a jail, and he was to be released in 1968. But you see, the irony was that he was to be released in 1964, but when the order copy was sent to the jail superintendent said that he was suffering from mental disease. So, he was to be shifted to the district health center, district hospital, so that his mental treatment would be done. But reports reveal that medical board had been conducted. Medical board had examined that he was not suffering from any mental disease. There was a contradiction between these two statements, medical board and jail superintendent. As a result of that, jail superintendent told that Ruddal Shah was not released because his treatment was necessary. So, that is why he was to be shifted from district jail to district hospital. But Supreme Court, even in this case, even in Ruddal Shah case, you see, the petition was filed by Kapila Hingurani. Ruddal Shah was in jail. He was not aware about his rights, ignorant about his rights. He was not aware about his rights. So, the petition was filed by Kapila Hingurani on behalf of Ruddal Shah, and matter was brought into the notice of Supreme Court. Supreme Court took the cognizance and state government was directed to provide compensation to Rudal Shah, and immediately he should be released. Supreme Court directed the state government that he should be released immediately because he has spent several years in jail without any reason, and state is responsible for the wrong committed by the jail superintendent by its representative. Since jail superintendent was negligent in this case, so on the basis of that, state would be liable for violation of human right. State liability for illegal arrest is established in this case. So you all must remember these two cases, and now come to this. There are two important case laws. State liabilities for custodial rape. If rape is committed in custody, then what would happen? Whether state is liable for custodial rape or not. With the help of these two important case laws, we will try to understand the Tukaram and others versus State of Maharashtra AIR 1978 and Chandrima Das versus Chairman Railway Board AIR 2006 Supreme Court. I have chosen these two important case laws. This Tukaram case is very important in Indian Penal Code IPC section 375. You can also refer this case in that chapter. Chandrima Das case you can also refer under Article 21 of the Indian Constitution. This is a leading case in that head, Chandrima Das. So, what I have highlighted in this case, it is the case of custodial rape committed by two police constables in police lockup. Liability was fixed. In Chandrima Das case, Supreme Court held that railway employees who were involved in rape, they were guilty and state was liable to pay compensation to the victim of crime. So, now question is whether rape is committed in custody. So, it would be a custodial rape, and the officers, the person who are involved in that incident, state would be liable for that, victims would be awarded compensation. How in these two cases, what happened? I just want to complete this. In Tukaram case, what a girl Mathura along with her brother, they went to a police station to lodge a FIR, but see, her brother was asked to wait outside the police lockup, and Tukaram and Atmaram, they committed rape against that Mathura. This case is also known as Mathura rape case. After this case, the entire law on this evidence was changed by the parliament, and what in this case, after that incident, when hue and cry was made by the victim brother, then she was escaped from the place, and when medical report was conducted, it was found that rape was committed against her. When matter came before the Supreme Court said that since no scratches were found on her body, so that is why it appears that it was a consented act. So, they were acquitted from the petition appeal on Tukaram and Atmaram, they were acquitted, and that decision was criticized. Justice V.R. Krishnaiyer in his dissent opinion expressed that in such kind of incident, women is always helpless. So, we should not draw inference that she should make wise raise objection against that act, and that is why. The second important case is Chandrima Das versus Chairman Railway Board. What happened in this case? Few Bangladeshis women were raped by railway employees when they were travelling from Howrah to Delhi. So, since it was a rape case committed by the employees of Railway Board, so Supreme Court directed the Chairman Railway Board that the incident, that act was committed by railway employees. So, Chairman Railway Board is also vicariously liable for that, and board should provide compensation even to the foreigners. So, in this case, Supreme Court for the first time held that even Article 21 is available to a foreigners also. Even foreigners are entitled to get the protection of Article 21 of the Indian Constitution. And Chairman Railway Board was directed to provide compensation to the victim, to the rape victims. So, this is the case. I have covered each and every aspect of state liability for violation of human rights, custodial rape, custodial violence, illegal arrest. So, with this, and state liability to provide food and other basic necessity, even where state has failed to provide food to its citizen and starvation death is going on, if people are dying due to hunger, then state would be responsible for that. Even Supreme Court has held this in these two cases. I have also highlighted. So, due to time constraint, with this I would like to conclude. Thank you all.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. One of the things you must have noticed if you read or if you talk to people around you is that they often refer to something called globalization, or they often say we live in a global world. What does this mean? Today I'll tell you about how to think about globalization or interpret the word global in a sociological manner. When sociologists refer to globalization, they refer to three things. The first is that that it involves transplanetary processes, which means that something is going on across multiple borders, right? The second is that it involves heightened liquidity and interconnected flows. Now, by liquidity, and this is a term that was coined by the sociologist Zygmunt Bauman, we refer to the increasing interconnectedness of things across the globe, but we also refer to increasing instability across the world, which means that potentially something that is occurring many kilometers away from you actually influences the place that you live in. So, if there is a natural disaster happening in one part of the world, maybe that causes people to migrate from that area and they come and settle where you stay. So, that is what we mean by liquidity. And of course, when we are talking about liquidity, we are talking about things that are really moving from one place to the other. Now, the third aspect, and this is something that you may not conventionally come across in the way people use globalization, is that of structures. So, let's take an example. Supposing I, as an Indian citizen, wish to visit a foreign country. Let's say I want to go to South Africa. Can I just pick up my bags and hop on the next plane and go to South Africa? Any logical person is going to say, no, wait, you need to have documents such as your passport or visa. Now, this passport or this visa is a representation of the larger structure that governs how people move across borders. So, we have things like border control, national security agencies that consider what kind of people are going to move from one place to the other, correct? So, when we think about globalization, an average person typically tends to think about things moving or people moving from place to place. As sociologists, we also consider that there are structures that facilitate or direct this movement across multiple borders.